Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, is with us every Thursday to bring her legal experience to the table and to the radio by providing general advice on the latest hot topics. She has experience that spans more than 25 years in the area of property and commercial law, and she joins us as usual for a Thursday morning. Good morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning. So Q&A day part 2.
Q&A.
Great.
Woo-hoo!
I'm excited.
Very exciting. So last week we spent some time answering a bunch of questions. Well, actually it was kind of just on one. Whistler from Yamba wrote in an excellent question regarding masks and QR codes. And this week we've got more questions and we're here to answer them, or Despina is. We'll ask you these questions on the spot. And we had lovely Vicky from Pottsville write in. And this one's an interesting one. She said, I am allergic to EMF from microwaves. If I am exposed to EMF for any length of time, or depending on how strong the radiation is, it will make my ears ring for at least 24 hours. It's pretty hard to escape them, as you can imagine, with Telstra initiating more mobile phone towers and upgrades to 5G. Are there any laws that protect EMF hypersensitive people from being radiated against our will, even in the privacy of our own homes? So it's a tricky one because obviously it involves, I guess, a medical issue as well. So what do you think on this one?
Well, it's a little bit of a curious one. I don't know, or I've never heard the term of EMF hypersensitivity per se. So I don't have a medical degree, so I don't really know if something or what it means. If this person says she has it, I'm sure she has some sort of condition that she's concerned with. But as to whether these towers affect her and that condition and what she can do about it, well, first of all, I'm not aware that there is any evidence of any a detrimental impact of people living near towers. I know that there's been a few articles over the years about what they may give out in terms of the towers, the radio waves, or the radioactivity, whether that's going to cause any long-term damage to people health-wise. But I don't know of any evidence that exists at this point in time that would help this person. And I guess, the only thing I could point this listener to is perhaps look at the Human Rights Act, because the Human Rights Act that we've talked about in recent times is there to protect individuals' rights in terms of, their privacy, the restrictions upon their life. So it may or it may not be something that she can pursue. But I think the first port of call is to actually get medical evidence about her condition. Yeah. So she says she's got this hypersensitivity. Well, has it been diagnosed? Have you seen a doctor? Do you have a medical certificate or report that actually talks about this condition being a real condition and that it has to be monitored and dealt with and treated? So I think that's the first protocol. And if you do, then maybe go to the Human Rights Act and you can look at that in the future. But until we get more evidence, it's a little bit sketchy.
Tricky one, yes. Well, thank you for writing in, Vicky. We really appreciate it. Coming up, this one is from Sally from Southport. Has a lovely ring to it. How far can a body corporate go with obtaining evidence against a lot owner for a possible breach nuisance by law in relation to pets?
Ooh, this is a tough one. Lots of people would like to know the answer
so
to
many
this
ears
one.
just went, hello there. What do you think about this, Despina?
Yeah, great question. I will do my best to answer it. I think the best way, perhaps if I can use an example of a client of mine that was in a situation a couple of years ago on the Gold Coast dealing with a body corporate in relation to her pet. So I think that I'll use that example to try and answer this question. And it was a really, it's right on point actually. This particular client lived in a unit, obviously strata titled on the Gold Coast, and she had a cat. Yeah, and the cat was black predominantly, but she started to receive breach notices from the body corporate about her cat being a nuisance. In particular, at night time, the cat would escape, apparently, and would jump from balcony to balcony.
Ooh.
So,
so dramatic. I love it.
Yeah,
very dramatic. And then what was happening was, I suppose, jumping from balcony to balcony, everyone's asleep, maybe not so much of a nuisance. But what was happening apparently was that the cat eventually got down to ground level and then wandered around the grounds, which is common property, and started to leave their business on the lawn. So, not good. And of course, that can be considered a nuisance. And yes, in strata titled buildings, body corporates are very strict about looking after your pets, making sure they're not a nuisance. When they are walking or using common property, you've got to look after them, make sure they don't create messes and nuisances, even with barking or with other noises, or being a nuisance to other residents. So that is a very important bylaw. So what happened in this case is that the owner said, look, it's not my cat. There are other cats in the building. They said, no, it's your cat.
Your cat, yeah.
And she said, how do you know that? Oh, well, we know because we have infrared. We've used infrared camera video footage, I should say, and we've filmed your cat jumping from the balcony to another balcony. And she rang me and said, what can I do about this? This is dreadful. I mean, can they do this? And how can they do this? And it was in the middle of the night. So this body corporate was going to some extent to gather up evidence to prove that it was her cat.
Pussycat.
The poor pussycat.
Yeah.
And really, how clear is this infrared? So, like, how do they know that it is this jet black cat? You know what I mean? Like, footage at night, that's hard to tell.
Yes, well, she argued it because her cat had white paws. So she was saying it's not my cat.
Yeah.
She was quite firm about it, but they were very pushy. So in the end, the short of it is that she ended up leaving because she couldn't. I could use the word quote unquote beat the body corporate because they were adamant it was her. She said no, that she kept getting breach notices. There wasn't too much more she could do about it other than she sold the unit and left somewhere else because of the body corporate committee that was involved, and it was very, very nasty. But I guess in terms of your rights, if they're using infrared footage, they're obviously taking it from somewhere outdoors, so somewhere from that's not obviously on your balcony, that's from another area within the building, like on common property. So I guess from my point of view, I have issues with privacy. So if they're filming it and the curtains are drawn or the blinds are drawn, they're not viewing anything else. So we don't have an issue of privacy, do we? But if they were filming at a time when the curtains were open and they weren't drawn and they were filming other things, there'd be an issue there with privacy, I would have thought. So it depends on what is shown on the footage, I think. But I guess the body corporate does have a right to gather evidence to prove that something has occurred. So they can go and take reasonable steps that they consider are reasonable. I thought it was a bit far myself at the time, using that sort of footage in the middle of the night.
Middle of the night, infrared technology.
Yes.
So were they within the law? Were they doing things legally?
Well, it would seem so to a certain extent because, as I said, as long as they weren't breaching any privacy rules, in particular, that they gathered up evidence. I suppose it's like filming a cat. Once the cat jumped onto common property from another area, they were able to film that and then use it to say, well, it is common property. We manage the common property. It's our role to do that. And now we have to deal with this nuisance.
Because ideally they'd want to see it coming from her apartment or whatever. But what if it's on her balcony? Isn't that her balcony? Is that still a
It's interesting.
space?
It's interesting, isn't it? Because the balcony normally in a strata title building, the balcony is within the lot. So the balcony is considered your within your lot that you own.
Yeah.
But then it gets tricky because once you go on the rails and then you go on the side of the building, it becomes common property.
Which belongs to everyone.
So it's a very tricky area.
Yeah.
Yes. Which is why they probably thought they had the right to start taking these steps to gather up evidence. And I suppose on the flip side, the lot owner says, no. The body corporate says, well, yes, we know that because other people have seen it and reported it. And then the body corporate has to obtain independent evidence.
They've certainly gone out of their way to get this evidence, haven't they, in that case?
Yes, so perhaps if I was in her shoes, I probably would have done the right thing, or the same thing, I should say, and probably just leave, and dealing with a body corporate like that would take those steps. But anyway, yes, hopefully that's answered that question.
Yes, very interesting question. Thank you so much for writing in, Sally. That is Despina Priala from Priala Legal. Don't go anywhere. We will be answering more of your questions just after this right here on Radio 97.